Hi everyone, I'm Sharada Mani, Assistant Professor, Department of Commerce. Today we discussed about modes of winding up. Let's see. So, modes of winding up is divided into two types. One is compulsory winding up by the tribunal, and the next one is voluntary winding up. Okay, voluntary winding up refers to as a voluntary winding up when a company is wound up by its member and the creditors without the intervention of a tribunal. In voluntary winding up, the company and its creditor are free to settle their difference without having to the without going without having to go to the tribunal. Although the company, the liquidator, or any contributory or creditors may apply to the tribunal for directions or orders as and when necessary for their resolution of any questions arise during the winding up processes. It should not be noted that there was two types of voluntary winding up. The first one is voluntary winding up of members, and the second one is voluntary winding of the creditors. Members voluntary winding up was the reason to buy solvent companies when they were insolvent. The directors submitted a declaration of solvency to the register. Insolvent companies, on the hand, used creditors voluntary winding up when directors failed to make declaration of solvency. The above distinction was abolished by the Companies Act of 2013. There can be no voluntary winding up under 2013 Act if the declaration of solvency is not made. Okay, grounds for the voluntary winding up is Section 2304 state that the company may not be would be wound up voluntarily in one of the two situations. The first one is, though the adoption of the ordinary resolution, a company may decide dissolvency voluntary by the ordinary resolutions when the period specified in the articles of incorporation for the duration of the company has expired. When the event for which the article provides that the company shall be dissolved has occurred. The next one is by passing a special resolution. A company may at any time for a reason pass a special resolution to be voluntarily wound up. Okay, when the resolution of the voluntary dissolution is passed, it must advised within the 14 days of passing of the resolution in the official gazettes as well as the as well as uh, in the some important newspaper circulating of the district company register offices. So the next one is the process. In the process is divided into 7 types. The first one is company, the second one is creditors, the third one is shareholders, and fourth one is progressive creditors, the fifth one is register, sixth one is liquidators, and the person should authorize it on the both state and the central governments. A company may be wound up in the tribunal order. It is to be so in the accredited with chapters which addressed the revival of the rehabilitation of the sick companies. The company business is being operated in a fraudulent manner. The tribunal may issue a winding up of if upon the register or another other person request to the tribunal determines. The state of the company was formed for faulted and unfavorable process, or the persons concerned in the formation or management of its affairs have been guilty of fraud, mistrust, and misconduct in connection therewith. Failure to pay on demand. When a company fails to pay the or otherwise safety a creditor to whom it's owed more than rupees 1 lakh within 21 days of creditors or his agent or legal advisors demand for the payment. Unsatisfied and decreted debit, when a company fails to satisfy decrease issue by any court or tribunal in the favor of a creditors, in whole or in part. Please keep in the mind that there is no in the case any amount is unconditional and satisfied execution of the disagree, no matter how small, will constitute inability to pay. It providing the inability to pay debits commercial insolvency. A company is also deemed to be unable to pay its debit if the tribunal is satisfied that a company unable to pay its debit. When determining whether a company is unable to pay its debits, the tribunal must consider the company consignment and prospective liabilities. If a company cannot determine it and its asset are insufficient to meet its liability for a responsible time, if may be considered commercially insolvent. Just and equitable reason for winding up, the tribunal may ISO order for the winding up of a company if the tribunal believes that is just and equitable to it. The tribunal has a board of discretionary powers under the cases. When it is appeared to be just and equitable, the tribunal may order the dissolution of a company. What is just and equitable is a question of fact determined by the facts of each case. It make an order under this case. The tribunal generally consider the interest of a company and its employees. So thank you for watching.